Good evening. My name is Jessica Saxton. I'm a civil rights advocate and litigator from Washington, D.C. I need to provide a public notice to you today, and this is in accordance with USCS rules as well as the Rule 17 and Rule 20 of the United States Supreme Court. The Constitution for the United States of America is the overarching requirement that we are to follow. Every state must follow that. I don't think that anyone here would disagree with that. States are not able to enact its own alternative legislation in substitute for the guarantees of the Constitution of the United States. That would mean that the state laws are in fact more powerful than the Constitution. Clause 1 of Amendment 5 states that no person should be held to answer for a capital or otherwise infamous crime unless on presentment or indictment by a grand jury. The state here, Iowa, has enacted its own alternative legislation that permits the prosecuting attorney and police officers to charge by way of information as opposed to indictment. That is unconstitutional. An emolument violation is when you pay public officials to commit a crime. There's two areas in the Constitution that enforce this. One is Article 1, Section 10, where it says that no state shall create any law that shall impair the obligation of contracts. Police officers, prosecutors, your judges are all under oath, a contract to perform based on oath or affirmation that they took. The contract perimeters here are defined within the Constitution of the United States, and when the state enacts its own alternative legislation and directs their agent to disobey the law, which is the Constitution of the United States, that would be a violation of Article 1, Section 10. The 14th Amendment is the other place where you find the reinforcement of this issue, and that is where it says that no state shall create or enforce any law that shall abridge the immunity or privileges of a United States citizen. The privileges and immunities of the United States citizens are at a minimum those that are enumerated in the first 10 Bill of Rights. The first 10 amendments in the Bill of Rights. They cannot be impaired. The state of Iowa, unfortunately, has enacted a law that is inferior to the Constitution that permits public officials, law enforcement, who you all pay, to violate the Constitution. Tanawah Downing is preparing to litigate this issue at the United States Supreme Court on behalf of more than 700,000 prisoners that are currently incarcerated here in America unconstitutionally and illegally. I am here today to provide you notice that if you continue to pay public officials to break the law, that there can be criminal sanctions that can come with that. Nobody wants to go down that path because we believe that it will be very messy. Nonetheless, officials must be made aware that they are paying people to disobey the law. This is an emolument violation. It is illegal and it is unconstitutional.
Thank you.
Thank you. I need to put this on the record if you don't mind. Where can I direct this?
You can give it to the clerk.
Thank you, sir.
Good evening. My name is Tanawah Downing, and I'm a national civil rights advocate and litigator that Ms. Saxton was just talking about. The reason why I'm up here now is I want to urge you all to please take a look at Amendment 5, confirm the things that we're saying, and let's direct our agents to act in a lawful, constitutional manner, consistent with the obligation that they have codified within the Constitution of the United States. This is a very, very big deal right now. And I want you guys to understand that, what we're doing as of this moment, we've already served your Attorney General, Iowa State Attorney. We've already served your Supreme Court justices. I'm prepared to argue this at the United States Supreme Court. This is a prima facie per se crime, because when a public official just decides to rely upon an inferior state statute to deprive a person of a right that's guaranteed by the Constitution of the United States, that is a crime. It's Title 18, subsection 242. Deprivation of rights under color of law. What that states is that any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any rights secured by the Constitution commits that crime. This is a per se crime, which means that we don't have to prove that they intended to breach their obligations. Simply by virtue of the breach, all elements of crime have been met because their willfulness and their knowledge derives from the promise they make. If you make a promise that you'll do something, and you fail to do it, then we don't have to show that you intended to do it because of the promise that you made. You've already implicitly invited punishment in the form of perjury. The reason why we're here with you guys right now is because you guys are paying these public officials to do their work. And so if these public officials, police officers, sheriff's department, the jail, if it's housing individuals that have been unlawfully and unconstitutionally arrested because the state of Iowa did not follow the proper procedures codified in the Constitution of the United States for the adjudication of crime, then you guys are paying for these things to occur. And that means that you can be held culpable in that, because when it comes to the crime of conspiracy with regard to public officials, it states that any person who, having knowledge of any of the wrongs conspired to be done, and who have the power to prevent or aid in the prevention of the commission of same, neglects or refuses to do so, may be joined as defendants in the action. So we brought this to your attention. This is one of many stops that we're making across the country. We started yesterday in Indiana, and we're now doing 55 stops over the next 40 days, providing notice to individuals that are paying for these crimes to be committed, and asking them to please, let's correct them so we don't have any further litigation, and we can go into this argument together, jointly working to correct these unconstitutional acts that are being committed by law enforcement officers and public officials. This is the least destructive way to do that. So I urge you guys to please, let's work together and let's make this happen. So I'm gonna have a seat here, and I'm gonna remain here until after this meeting is over. But I do want you to understand that I've spoken, or we've gotten word back from Kash Patel, the director of the FBI, and he has agreed that any time that a state judge chooses to violate a federal law, that they are subject to arrest.